Hi, this is Professor Chad McGuire, and welcome to our final video lecture on the topic of pollution in our environmental law series. We've had two previous topics on pollution. We had an overview of pollution, and then we had some focus in our second video on private controls of pollution. And now here in this video, we will be discussing public controls of pollution. As a reminder, all of these videos can be found. At the end, you'll find a list, a connection to the entire library of lecture videos, including a playlist specifically for environmental law, as well as references maybe during this video to some of the other videos that are relevant in some other areas like administrative law, hierarchy of laws, as we'll see. But you'll have exposure to all of these videos and information. So as we get started here on environmental law, focusing on public controls. By way of introduction, major differences, just to bring us forward and remind us of some of the things that we've already talked about. Major differences between public and private controls of pollution in the United States vis-a-vis major federal environmental laws. The focus generally, when we talk about private controls, is on the individual. And what that means is that the way that the laws are established under private controls, nuisance, negligence, these sort of common law actions, they really focus on individual conduct. So those laws, they come from a long history. You can go into the introductory and overview, not only of environmental law, but of our pollution, our overview in the pollution section, to be reminded that we have a common law tradition in this country, in the United States, and that's carried over from historical connections to England before we were an independent country. And many of those common law traditions that England has developed were inherited, at least in part, from Roman law during a time when, when Rome sort of inhabited portions of England or Britannia at that time. So we're talking about sort of traditions that go back literally thousands of years. In terms of understanding basic senses of rights and differentiation. And we talked about this in terms of many of those private law remedies that we have carried forward today, whether they're under common law tradition that's not established codified law, or some of those common law traditions like nuisance or negligence in some states, for example, in the United States, have been codified, put into statute regardless. They generally focus on individual behavior. And that makes sense, because if we bring forward that historical sort of sense or thought process, we're thinking, well, what are we talking about here in terms of the environment? We're really talking about, are we talking about a government that's controlling behaviors en masse, like large scale policy orientated environmental protections? No, we're really talking about individual behaviors and the controlling of individual behaviors as a means of trying to sort of associate and get society sort of individual behavior patterns, sort of lined up with the values, beliefs, and norms of society at that time, and providing an early example of how these laws would provide rights against individuals. So for example, if I have land and I have a legal right of ownership of that land, we can think about that. And then I have a neighbor, and that neighbor is doing something on their property as a separate private individual. They might own that land, but they're doing something that interferes with my, reasonable use and enjoyment of my land. Then, I can try under the law, I can try to claim some sort of right that they're, and this is nuisance, for example, that they're harming my enjoyment of my land, and therefore I would seek redress from the government. And in our system today, that would be the court system, the judicial branch of government in the United States. But I'd seek redress against that individual by going to government and saying they're doing something that violates my reasonable interest in the use and enjoyment of my land. Therefore, please do something to make them stop what they're doing. So, we talked about an injunction, for example, in the private remedies as one of the examples, that we stop the offending activity, and maybe also damages might apply, like they've done something and they've been doing it and it's harmed my property in some way that has diminished its value or diminished my enjoyment. And therefore, not only should you stop them from doing it, but you should provide me with some compensation for the harm. That's, in quick summary, what a nuisance sort of claim might look like. We talked about Boomer and Spur under private remedies of pollution, 2 cases that talk about trying to balance these interests using these private remedies against individual entities, in this case, a cattle feedlot in Spur, or a cement company, and it's Atlantic Cement in the Boomer case, against residential individuals, a number of individuals in a residential neighborhood versus a large planned residence in the Spur case. But we have those sort of juxtapositions to look at in terms of, well, this is an action against a private individual doing something that is offending on their property, which makes a lot of sense. But it's very individualistic, meaning if we find a nuisance, if a court, for example, finds a nuisance against the individual, the neighbor to your property, it only applies, the court remedy only applies to that individual. It doesn't apply to everybody. So it doesn't say everyone, FYI, for your, as a matter of future reference, do not engage in these types of conducts on your property, because if you do, then it's going to be considered a nuisance, or you're prohibited proactively from doing it. It doesn't have that kind of universal approach. So one of the things we talked about is that from a policy standpoint, when you're thinking about environmental laws or creating a regime of environmental protection, these private remedies are limited in the sense that they really are individually focused on specific cases and specific instances. And any remedy that the government, vis-a-vis the judicial branch, the courts, might apply, that remedy is also individualistic and specific. It doesn't have a wide-reaching effect, at least immediately. It might create precedent for future cases, but that requires every one of those individuals, in our example, every landowner that feels like they're being harmed, to go to court against the person or persons or entities they believe are harming them in that instance. So it's a very sort of, if we use the economic term, it's high in transaction costs for those private individuals. But aside from that, that's really what private remedies, when we say that they're individually focused. Public remedies to pollution, these larger scale environmental laws we talked about in the introduction overview, the Clean Water Act, the Clean Air Act, are the 2 we really focused on and we really overviewed in that overview section. They're really focused more on a environment as a concept. Now, we've already talked about and discussed, but as a way of review, environment, that's a normative term. What does it mean? Well, it's not unlike beauty, as defined as in the eye of the beholder, right? So you and I can come to different definitions, or at least operational definitions, of what the environment means, what it should mean. And certainly the environment has different definitions and different meanings under different laws and different statutes. Most of the time in US environmental law, when we're talking about the environment, we're talking about that human-centered environment, the environment as related to human well-being. We noted in the Clean Water Act, for example, water quality standards. Well, what does that mean? How clean does a body of water need to be? Or in the Clean Air Act, air quality standards. How clean does the air have to be? Can we have water quality standards that protect, human well-being, but harm a lot of other species or other ecosystem components? So it's like, well, the water can be dirty enough as long as it doesn't kill humans. That's okay. We consider that to be okay, again, because we're putting humans at the center of our definition, our operational definition of environment. But anyway, it's a wider approach. Regardless of how we define the term environment, these public control mechanisms really focus on a wider sphere of influence. So if I'm talking about the Clean Air Act, I'm talking about the air in general, right? Air as applied in general to everyone in a particular area. We call it an airshed maybe, right? A specific attainment area, an identified geographic range. Same thing with the Clean Water Act, for example. We can say water bodies, right? We can look at those water bodies. Those water bodies might be large. Think of the Great Lakes, for example, or even think of the Gulf of Mexico, some of our coastal areas, right? Quite large, quite expansive, expanding a wide range of area. And we can think about how watersheds, including the Mississippi River, for example, the entire watershed of the Mississippi and the Missouri, right, running through the main part of the United States, the middle of the country, really large swath of area. And we can think about, well, that's comprehensive. If that law applies to all water within these areas, that is really substantial. So if we develop standards of cleanliness, regardless of how we develop them, and we apply them equally, they have a wide-ranging effect. So as opposed to private remedies that are really focused on individual actions and limited in any remedies that are identified or any sort of wrongdoing that's identified, public controls really are more comprehensive. So that's a major, major difference between these two. As far as judicial review, we talked about this as well under the private remedies, a lot of discretion. So when a court is reviewing, let's say, a violation of a nuisance or negligence action, right, for some environmental harm. And in this case, we'll talk about pollution because that's our subject area. It includes other areas like land use and things like that, but we'll get into that in our next section when we talk about land use. But for now, pollution, mostly air, water is what we've been focused on. As far as judicial review, when I'm talking about a common law sort of remedy, I have a really large sort of window of opportunity to develop remedies when I'm a judge. And we saw that. We saw that in Boomer, and we saw that in Spur, those two cases. We saw where the judge, the court is really capable of fashioning a remedy very specific to the facts of the case, which is great because sometimes those remedies can carry with them a lot of sort of this cost benefit analysis where you can really try to think of the fairness relative to the parties, you know. So we knew in Boomer, for example, we knew that there was a residential area that was being affected by the new development and operation of a Atlantic cement company. And that cement company was significant for the relatively rural small community. A lot of jobs, a lot of economic activity, a lot of tax revenue, especially considering millions of dollars for that area at that time, 60s, 70s, 1960s, 1970s. So it was had significant economic benefits for the community. Of course, it had an impact on those homeowners. And so traditionally, if you found a nuisance, which the court found in the Boomer case, you would say, Atlantic Cement, stop your operations, stop emitting that stuff as a byproduct that goes into the air and affects the reasonable use and enjoyment of these private landowners that are near you. Stop doing it. But in this case, the court said, well, that would, if we stop them from operating, it would have a significant economic impact. So rather, we're going to have them pay for the effects, pay for the damage that's caused by their activity to the landowners, or, you know, and there's a number of ways to look at that. Pay for the damage that they're causing, pay for the diminished use and enjoyment of the property, right? How much do you pay? How do you establish that valuation? What are we talking about here? So there's a number of ways that can be done. You know, you can come up with a reasonable determination based on a number of factors of what the diminished value, what does it look like, right? What is the economic impact? You could say, well, these houses, right, for example, could have sold for this without being located next to, a cement company. But now that, you know, they are located next to a cement company, the, you know, fair market value of the homes have been reduced by 20%. So that's the damage value. Or it could be, you know, we can come up with a value, a marginal value of days of, you know, enjoyment of your, you know, being outside in your backyard, that kind of thing, and what that's worth. We can come to some valuation, and then we can just sort of multiply that by the number of days that the air quality is diminished by the activities of the cement company in a given year, multiply that over a lifetime, that sort of thing. There's a many way, and then of course, discount for present dollar value, so on and so forth. There's all kinds of interesting and neat sort of accounting methods that can be used to come up with a valuation. We don't need to discuss those details. That's something different, but the idea is there's a lot of detail that we can look at, and there's a lot of room for sort of interpretation in these private remedies as far as a judicial review and fashioning a remedy to the particular harm. From a public standpoint, generally judicial review is constrained, and that's because the statute, the Clean Water Act or Clean Air Act, when it was created, the legislature that created it often puts in, you know, specific remedies, often identifies what the remedies are in the statute. And we'll talk a little bit about that. But the point is there's more constraint as to what a court can do in terms of fashioning a remedy that seems to be fair. And again, the question of fair, hey, what are we talking about here? If we're talking about, like we talked about the Boomer case, the court's thinking about the economic benefit of the cement company. Again, human well-being is put at the center, not only of the definition of environment, but it also becomes that kind of economist. We talked about the economist versus ecologist view when we think about the definition of environment, the operational definition. In many of these sort of common law or, you know, private remedies that we've talked about, really those views tend to focus on sort of a cost-benefit analysis, which really suggests that the environment is always being balanced against, however we define the environment, it's being balanced against other human interests, economic valuation, economic output, that kind of thing. So it really is that sort of economist point of view. And we see that a lot in these private remedies. And sometimes in the public remedies, because the environment is more of a consideration, however we define it, at least in part, we can say that there's more of an ecologist viewpoint, because we're looking at the environment as a background condition of well-being. Again, it can be defined through human. We can have a whole discussion and we can understand that there's a distinction to be made where we say, well, water quality vis-a-vis human well-being versus water quality vis-a-vis ecosystem well-being. That's certainly true. But when we're talking about water quality in any way and having it programmatically applied to large swaths of area for all human activities, then we start moving away from that sort of really heightened individual focus of private remedies and moving more from an economist point of view, at least our cartoon economist versus cartoon ecologist. Caveat, or we said disclaimer that this is just a binary. We're creating this sort of false binary that there's a spectrum and that there's an economist on one end and an ecologist on the other, but we know that's not true. We know that there's all different sort of variations, that not all economic thought is anti-environment or willing to be put as a juxtaposition to environmental natural ecosystem well-being. That's certainly just not the case. But for our purposes of simplification, in our model, we have our cartoon economists on one end of the spectrum and our cartoon ecologists on the other end. And certainly ecologists who don't consider humans as a part of a natural process, right? It's maybe because we're part of the environment. Our actions are maybe as, certainly as legitimate as a beaver damming up a watershed and altering the watershed's ecosystem, or, many other species that just interact, move into different areas and, have impacts and effects on what is considered the background environment. So the point is this juxtaposition, this sort of, putting them on the opposite ends of a spectrum is not exactly true, but just to understand what we're talking about, we can say that although judicial review is constrained in these environmental contexts when looking at the public control mechanisms of statutes, we can say that that constraint is really favored, generally speaking, more towards a wider view of environmental well-being. And so courts often, maybe if they say, well, it might have a huge economic effect on the area in order to require these significant or, changes to this coal burning power plant in order to comply with Clean Air Act standards, right? It could have a huge economic impact, but you know what? That's just the way it is. That's okay, because the statute says that you must use best available technology in order to protect against, and there is technology and it's going to cost what it's going to cost, and it's better than what you have, and it's going to have a protection. If that's what the statute says, then, my hands are tied. The judicial branch, we must follow the clear message of the statute here, and therefore I cannot consider economic impacts unless the statute allows me to. And sometimes these environmental statutes do, sometimes they don't. But the point is that there's more constraint in terms of how far a court can go in interpreting not only whether there's a violation of the statute, but also what remedies are available. So there's those major differences in terms of focus and in terms of judicial review. In addition, focusing now on public controls. Public controls place the environment more at the center of the approach. I think this should be known and understood relative to private controls. Whatever definition of that environment is, it's more at the center. So we can say, as a result of that these public controls are more of a systems approach. They may be an incomplete systems approach, depending on how you want to define environment. They might not protect or focus on the environment in a way, a normative definition or operational definition of environment that some would favor, but however they identify or define environment, they apply more of a systems approach to that definition. And they still use human health and well-being as primary goals, right? We know this. So even though often that definition, that operational definition of environment is not perfect, it's not a perfectly natural system definition. It has a lot of, human priorities, human health and well-being priorities. The key, I think, is environmental harm is a consideration when determining the violation of the law and appropriate remedy for violations. So I think the take-home message here in terms of, look, if we're talking about private versus public control mechanisms, private control mechanisms really consider the individuals and really focus on the individuals, and the environment is sort of a secondary or tertiary consideration. The key for public controls, Clean Water Act, Clean Air Act, is that environmental harm is a consideration when determining a violation of the law. So environment, however defined, its harm is at the front and center. It's central to the consideration of a violation. And as a result, what remedies might be available. So that's an important thing to know and understand in terms of juxtaposing private versus public controls of pollution, or generally speaking, of environmental laws here in the United States. I can bring this forward. I think we've identified this in the past, I think in the previous or in the overview. Here we have a general spectrum just as a way of sort of visualizing and summarizing a lot of what I just talked about, is that if we had a spectrum where we have, on the left-hand side here, the focus is on harm to the individual, if we look at this, and on the right-hand side, we have the focus on the harm is to the environment, then we can separate these two categories. That common law remedies, nuisance negligence, are really towards this focuses on the harm to the individuals, whereas statutory law public remedies are really more towards the right over here, and the green, which focus more on harm to the environment. So that's a pretty decent way of just conceptualizing. And of course, there's all of this in between. One of the benefits of seeing this visually as a spectrum is, like I'm saying, it's not just a binary. This would be our economist and this would be our ecologist here, our cartoon economist and ecologist, but really there's just a whole spectrum. And what about here, right? We might find situations where we have laws that are very much like this, that are super focused on environmental well-being. You might think of the Endangered Species Act, for example, or the Wilderness Act, but statutes that really marginalize other factors, and really heighten the idea that, look, we're going to focus on this species simply because they're endangered. They're likely to go extinct if we don't change behaviors, if we don't change conditions and behaviors, and that becomes the primary consideration, the focus of the statute. But then we have others. And some, maybe the Clean Air Act and the Clean Water Act are more along here on the spectrum, where they're sort of moving in this direction, and even the statutory language and maybe even amendments provide more judicial discretion in fashioning remedies, where it's like, well, you can consider, right? So, generally speaking, best available technology, but you can consider economic impact, right? So but you can consider economic impact if that language then finds itself into one of these statutes, whether it was originally placed there or if it's based on an amendment, a recent sort of refashioning or revisioning of the statute, then we can see that the statute is moving more in this direction. And we can see that there are instances where there's a lot of this shared space between statutory law and common law remedies, where they start moving. So what I like about this visualization is that it provides us conceptually beyond, it helps us move beyond this binary approach where we're like, well, it's either one or the other. No, there's a whole world. And even in common law remedies, there are common law remedies where there's a hyper focus on the harm to the individual and balancing the interest. But there are also situations where you can use common law remedies under either the facts or how that common law remedy is through previous court decisions and maybe even statute. So the common law has been codified, like I said, in a particular instance, not necessarily at the federal level, but sometimes at the state level in the United States, where it's been codified, and it provides more of a balancing approach, where it says, no, the environment should be more of a factor in considering your remedy, even if it harms economic interests, even if it seems like on net it's an economic loss or direct economic loss. We talked about total valuation previously. That's in the overview. That's also in our overview of environmental law, generally speaking, if you haven't seen those. So go back there and if you need to know about total valuation. But the idea of total valuation is that, there are things that we don't have markets for that are still really important. Whether, direct economic value is generally the things that we have market values for, and we have markets, therefore we can directly identify a value for something because we're selling it in a market. Then there's indirect, which are a lot of like the provisioning services. Like this is really important to provide the things that we really want to have, that we buy and sell in our market. So without these background conditions, these provisioning service conditions, it's really hard to get some of these things that we have active markets for, right? And so very simple is that, if whatever habitat provides nursery for fish species, commercially important fish species, without that habitat, you cannot get the fish that you're looking for. You just have a decimation of this species. So protecting that habitat, even if that habitat doesn't provide any direct, in and of itself, values for market conditions. We don't buy and sell that habitat or the things that exist in that habitat regularly. That habitat is incredibly important as a mechanism, right, for helping to turn out the commercial fish species to allow for the next generation propagation, that kind of thing, for the things that we do, right? So if we like lobster, or if we like codfish, whatever it is, right? If we like certain things, scallops, I'm thinking of things here in the Northeast, but all over the world, but whatever it might be. So having those background conditions are incredibly important to produce the things that we do have market values for. So that's an example, total value. And there's even things where we don't have those background, those non-use values, but you can look at that in more detail. But the point is, sometimes we have either through a variety of mechanisms, again, case law or codification of some of these common laws, that the courts really are emphasize more things we would consider environment over individual, and that moves more in this direction for those common law remedies. So that's what's nice about this visualization, and that's what it's meant to represent. As far as judicial review of public controls of pollution, first thing is we can bring in our hierarchy of laws here. And again, this is something that's talked about in our introduction to environmental law, overview of environmental law, that video. Also, there is an entire video on hierarchy of laws. It's in the administrative law lecture series because it's part of the administrative law course, but you can go directly to that. You can see in the playlist, administrative law, hierarchy of laws. You can go there and you can review in detail what we mean by the hierarchy of laws. But here in the United States, it's an incredibly important mechanism, I think, or I should say a framework for us to think about judicial review. Generally speaking, statutory judicial review. And here, what we're talking about with public controls is we're talking about statutory judicial review. So we can use it as an important way of thinking about a contextual framework for thinking about public controls. So the hierarchy of laws, what it does for judges is it provides constraints. It says, look, you're going to create a Clean Water Act or a Clean Air Act or Endangered Species Act or a Marine Mammal Protection Act or Hazardous Substance Control Act or any of the major federal environmental laws, and you're going to be in this world. Congress is going to create these laws, and they're at the federal level here, but states do it as well. But so Congress would do that, and it would be signed by the President of the United States in order to be formalized into a law, which is the finalization of the policy. And now we have a new policy, clean air, clean water, whatever it might be. In implementing that law, usually there's a delegation. That delegation says, look, Environmental Protection Agency, the Federal Environmental Protection Agency, or many other federal agencies, right? You have been delegated the responsibility of implementing what this law says, how go about protecting the air, the water, and you can do so by creating a number of regulations. What's important for us to remember is that the delegation, how that executive agency, the Environmental Protection Agency, et cetera, how they act has to be within the confines of the law itself. It can only create regulations that are allowed under the law. I use a box example, so I'm just drawing a little box here, trying to imagine that this idea of a box. So the agency must always act within the confines of the delegation. There are limits to the delegation. That delegation must be in compliance with the legal limits of the statute. And both the rules or regulations that are created and the federal law itself must conform to constitutional limitations. No law can violate the Constitution, whether it violates it, as intended, as the law was created, the actual language of the law itself, or as it's implemented, as it's applied, can violate. And certainly, if the law cannot violate a constitution, then the regulations, same way, can't violate any constitutional. So that's what the hierarchy of laws helps us understand as a conceptual framework. So the hierarchy of laws provides constraints for judicial review. Court can't say something that goes, a regulation, an agency taking action that's outside of its delegated authority is, sure, that's fine, no problem. And certainly if that agency action or the law itself, right, violates the Constitution in any way, then the court can't say that's okay, we're good with that. So the focus here is on statutory law interpretation and the role of the judiciary in reviewing and interpreting law, how it reviews that public law and how it interprets it. The judiciary ensures the purposes and objectives of the statute are being carried out in two primary ways. First, it ensures that the environmental statute facially, as the environmental statute is written, or applied as it's being applied under a particular set of facts, does not violate constitutional principles. It's effectively what we were just saying here. And also, the court ensures that the statute applies established framework, that the court applies an established framework of statutory interpretation. So we get the constitutional principles thing from our hierarchy of laws, we just examined that. And then the second is that the court must apply an established framework of statutory interpretation. So what does that framework look like, statutory interpretation? So as noted, the courts have limited discretion, unlike private controls, right? Have more limited discretion in applying statutory law to a set of facts, both in terms of finding a violation and in fashioning remedies for these public controls. The courts must look to the statute, its language, and decipher the intentions of the legislature. Sometimes it's unambiguous. So sometimes the legislature is very specific in determining what actions equate to a potential violation under the law, and sometimes it's not so specific. So sometimes the language is unambiguous and it is obvious, and it says, if you find a violation, this is what a violation means. And if you find this to have occurred, these are the remedies you apply. It's very explicit, the statute. So the court just simply follows the language. Sometimes it's less explicit. Sometimes it's saying, remedies can include or must develop remedies that are appropriate. Think back to that spectrum that we just showed, that visual spectrum between public and private controls. If the statute doesn't have very specific elements of redressability or of remedies, right? The idea of if a violation is found, this is what a violation means. And if it is found, this is what you do. If it doesn't have that very specific language, then it's more likely that the court has more capacity to fashion remedies based on, again, prior precedent, reasonable interpretation. That's what we're talking about here as far as what the court does in terms of statutory interpretation. How does it know what it's supposed to do? So sometimes the legislature is very specific in terms of what a violation is, and then sometimes it's specific in terms of remedies, but sometimes not so. And then the courts generally follow a process of judicial review for interpretation, where the precise language of the statute becomes controlling. So what does that look like? So here's the process of review sort of summarized in a sort of visual format. And the first thing we can say is there judicial review available under the statute? Sometimes there is and sometimes there isn't. And what I mean by that is we can talk about that, but that's a matter of maybe, for example, standing. Who's bringing this claim? Do they have the capacity to bring this claim? Is it right? Is it ripe for review? Have you met the other requirements? So even if you have standing as an individual in terms of showing harm, maybe you haven't shown that this is the appropriate time, because the statute says you as this person cannot bring this claim at this time. So the first thing we have to determine, or a court has to determine in these public laws, and this applies not just to these environmental laws, we're talking about, this is statutory interpretation in general, related to any federal statute. So the first thing that the court must do is determine, is judicial review available under the statute? If there's express language right here, then if the answer is yes, if the statute expressly allows for judicial review, great. But if the statute expressly forbids judicial review, again, it could forbid judicial review of the individual or entity seeking review. It said, no, only government can enforce this law. You're a private citizen, you're a private organization or a private group. So if the statute says only government and you're a private individual who has been harmed, like you were the, individuals in Boomer or Spur, the residential homeowners, even though you might be able to show harm, it doesn't mean that you can bring a claim, because the statute might expressly forbid you and say, nope, only government can do this. Only an agency, a specific agency, or an entity of government can bring a claim for a violation here. So there are instances where there is, the statute expressly forbids judicial review. And sometimes, there's more of just an administrative procedure. But anyway, if the statute is silent as a third option, then the Administrative Procedures Act applies. So in this case, what we're saying here is, it's a matter of judicial review, that the courts look to the language of the statute. And if it says, yep, there's judicial review available, great, we can move forward. If it says no, expressly says no, either in total or for the individual entity seeking review, then the court says, nope, no judicial review, we're done, have a nice day. You have no standing, the court has no jurisdiction here under this particular set of facts. Otherwise, if the statute is silent, then the Administrative Procedures Act applies. Now, the Administrative Procedures Act is its own thing. It's something that is described in detail under administrative law. Like I said, there's another playlist for not only hierarchy of laws with details on hierarchy of laws, but you can also find administrative review under the Administrative Procedures Act. There's an entire detailed video lecture on the Administrative Procedures Act. You're more than welcome to go there and take a look at what that means and get more in depth on the Administrative Procedures Act. If that's what you're looking for. Obviously, students in the course have more details available to them and other materials, but if you're just looking at this from the outside, so you can go there and get a little bit more information on what the Administrative Procedures Act means. So this just showing us for judicial review purposes under public controls, how we go about sort of thinking about this. So let's just deal with the APA really quickly and get it out of the way. So if the APA applies, the statute is silent, triggers the APA. And so the Administrative Procedures Act, in a nutshell, sorry, there's a lot more details, but in a nutshell, the review agency actions under standards of judicial review. And the standards of judicial review under the Administrative Procedures Act, based on a number of criteria, is either arbitrary and capricious, in excess of authority, or failure to observe standards. And those are three ways in which the courts will analyze the actions of government either acting or failing to act to enforce, or there's a whole process that's involved. There's a lot of detail that's provided in the textual material and other material for understanding that. For those of you that aren't in the course and are looking for more information, I would go to the administrative law playlist and I would look under the Administrative Procedures Act, and you might want to look these terms up to get a better sense under APA review to know when they apply, how they apply. So there's a different set of standards, and each of those standards are different. Sort of, if we used a scale, they provide a different way, a slightly different way of evaluating evidence and determining whether the evidence is sufficient. You've probably heard, most people have heard, even if they're not lawyers or have been indoctrinated into legal theory in the United States, you've heard that there's a different standard in civil proceedings in the United States than there is in criminal proceedings. And when we say standard, it's a standard of proof, a weight of proof. So using the scale concept, we can sort of think about it in order to overcome the burden of proof in a criminal proceeding, the evidence presented by the state against the criminal defendant must prove beyond a reasonable doubt, or beyond all reasonable doubt. Think of it as 99.9%. A lot of evidence, right? So in order for that scale to shift in favor of evidence supporting a conviction, let's say in a criminal proceeding, you must show a lot of evidence, heavy weight, 95, 99, 99.9%, a lot of evidence and a lot of weighting of that evidence to show that there's just, it shows beyond all reasonable doubt. As far as a civil proceeding, it's basically beyond, it's not beyond, it's a preponderance of the evidence. So we're talking 50.1%, just a little bit more. So there could be evidence, on one side of the scale, 49.9%, and just a little bit more evidence on the other side of the scale, 50.1%, and that's sufficient. What these standards here, arbitrary and capricious, in excess of authority, and failure to observe standards, they are also measurings. They're ways of measuring whether there's, whether there's a violation of a law under the Administrative Procedures Act. And most of the time, the violation will be a violation of government authority. Government has failed to do something, or government overstepped its bounds. It just depends on the sort of facts and what's going on. But it's whether government failed to take action, or whether government, took too much action took action outside of its authority. And these are the ways in which these are the sort of measuring standards on a scale: arbitrary, capricious, and excess of authority, and failure to observe standards. There's one way of thinking about these as weightings for and against. So that's the Administrative Procedures Act. Obviously, no, if the statute expressly forbids judicial review, then the court's done. So we don't really need to deal with that. We just have to say that the statute has to expressly forbid. And often the courts read statutes to interpret, allowances, unless there, again, it has to be expressed. So this has to be very obvious in the meaning, because the courts want to maintain jurisdiction often. And the courts want to say that they have, because they assume that Congress wants to get to resolutions. The whole point of passing laws is to have those laws have effects. And those effects can only be realized if they actually follow through. And when there's a failure for the law, when there's a failure of a statute to seem to follow through to its intended purpose, judicial review is really one of the main mechanisms in order to check that. The other mechanism, of course, is statutory revision. It's, if there is no judicial review, but everybody feels like there should be, the other alternative is to go and say, Congress, I want to elect, if I'm going to re-elect you, or I'm going to elect somebody else, change that, amend that statute to allow for more clear judicial review. So that's the other method outside of judicial review. But often the courts know that that's a very, that method often doesn't apply, or that method is hard to come by, hard to get, right? Amendments in that way. So courts, not that they, as a matter of fact, look to find a judicial review available, but generally speaking, they when we say statute must expressly forbid judicial review, when we say expressly forbid, it has to be pretty obvious in order for the courts to say, okay, no. So let's just focus on the yes. We'll assume that the statute expressly allows for judicial review, the public law. Oh, sorry about that. That's just a quirk of my mouse here. So the review, so if there is a yes, then they review other provisions of the statute to determine the extent of the judicial review, right? So if there is an express allowance, then the court looks at the entire language to determine the extent. And if the statutory language about judicial review is unambiguous, then that statutory language controls. You simply follow the statute. That's my example of saying, okay, if this happens, this is a violation. If the statute says that and it's clear, A, B, C, and D, any of these things happen, then there's a violation. So it's clear that statutory language is clear and unambiguous, generally speaking. If it's more ambiguous, if the statutory language doesn't give you sort of a direct identification of judicial review, capacity for judicial review, but there's language in there that suggests that there is, that you would have to have judicial review in order to affect the intended outcomes of the statute. So if it's more ambiguous, then the court reads the statutory language, the remainder, and asks if the actions taken are a reasonable interpretation of the statute. Has what government has done, or what these individuals have done, this entity has done, right? Is that a reasonable interpretation of the statute to fall within or outside of the statutory requirements, what the statute says? So that's kind of, again, statutory interpretation. These are all, very detailed. Any of these subject areas are entire subject areas that for at least a full semester course in law on these topics, if not really more, to be honest with you, to really try to begin to understand. So they're their own worlds of inquiry onto themselves. But for our purposes, we can just say private law remedies, private law interpretations, lots of judicial control, Public law, there's a process. You look to the statute, and there's no guarantee in the statute that the courts have the capacity to review under the circumstances, or in general, a capacity to review depending on the language. And this is the process the court engages in to determine whether or not it has the capacity to review a case in a particular violation, or supposed violation, alleged violation. After statutory interpretation of public law, putting that aside, what are the public law remedies to pollution? So what types of remedies fall under various federal environmental laws in the US? What can you get? We talked about in the private law, you have an injunction and maybe also damages, right? That's the injunction, particularly for nuisance, was always negligence, certainly damages, that sort of thing. We talked about that in the private controls. But what type of remedies fall under various federal environmental laws in the United States? Fascinatingly, there's criminal liability. And that's, a lot of people don't know this. So, and that can include heads of corporations for company actions that violate laws, and including jail time. So if you run a company that seem to violate sections of the Clean Air Act or Clean Water Act, and you have the types of violations that are considered to be continuous, egregious, that kind of thing, where you might have been put on notice and you didn't care and you continued the activity, then that company can be held criminally liable, the company. And as a representative, head of the company, you can have heads of corporations, CEOs, for example, have individual on behalf of the company liability. They can actually themselves go to jail for this. So it's pretty significant in the United States. And that is intended, of course, to ensure that these federal environmental laws are followed. If you have, what do we call these, paper tigers or things like that, I think are terms that are used, I know, in some ways, the idea that you might have a very strong law on the books, but the law has very little teeth or, very little effect because it doesn't really have significant penalties for violations of the law. So the law might seem like it does a lot, but it doesn't incentivize the kind of conduct. It doesn't incentivize compliance with the law necessarily, because there's just not much in terms of the penalties that one would pay. What are the remedies? What are the penalties that apply for violating this law? Well, many environmental laws in the United States have pretty significant teeth. They have to be prosecuted. So you think government action, right? So you need to get government involved in enforcing these laws, but in part enforcement, they can seek under statutory provisions, Clean Water Act, Clean Air Act, et cetera, Endangered Species Act, they can seek criminal liability. They can seek criminal penalties, and the courts are empowered to provide that kind of remedy under the statutory language. Obviously, if there's criminal liability, there's got to be civil liability. So that's the other side. We just mentioned that in terms of at least the weighting. But civil liability is including money damages, for example, for both actual harm that's caused and punishing the conduct if egregious, sometimes called punitive damages, but sometimes these are just statutory damages that exceed whatever the remedial sort of damages. So if you've committed harm, you can again come to some economic assessment of what that harm is, but then you can have a multiplier by statute, that kind of thing, in order to punish and or in order to disincentivize the same activity in the future. If you know that it's going to cost you $5 per ton of waste product of this thing under a penalty, and you're thinking about, geez, if I control that waste stream, it's going to cost me $10 to control it. Or if I just discharge it and get penalized, it's going to be $5. Then the incentive obviously is to always discharge, because it's cheaper to pay the penalty than it is to prevent the harm from occurring in the first place, the environmental harm. It's half the cost. So many of these laws contain, like I said, not only multipliers and, for additional damages to ensure that the penalty is high enough to disincentivize, but that's another reason we have criminal liability. So it goes beyond just the economic harm, the payment of financial penalties, and it moves into, well, we can take away your freedom of movement. We can put you in jail. So that's another reason to try to get compliance. And then, just like under the private law remedies, there are also equitable remedies, and that includes remedial acts. So that's like, if you've filled this wetland, now you need to reestablish the wetland, for example, because it was a violation of the Clean Water Act, the way that you filled this wetland, you didn't get a permit, you weren't allowed to do it. If you've destroyed this endangered species habitat, or if you've encroached on it, now you need to remediate, you need to reestablish the habitat, that kind of thing. So these remedial actions. Also injunctions, we've talked about injunctions under private remedies. So you can stop current activity and any future actions from occurring, specific actions. So those are the major sort of categories of remedies to public law violations or violations of pollution in many of these federal public environmental laws: criminal liability, civil liability, and equitable remedies. As far as citizen suit provisions, in private law remedies, the common law, citizens have a direct role in seeking redress from personal harm. We talked about that. It's in the Boomer case, the Spur case, nuisance negligence, really. So citizens are the mechanism, right? So that it is only citizen suit provisions really in these private law remedies, because they must bring forward. There's no government entity that's bringing forward on their behalf. Now, I should say, there are public nuisance, right? So we talked about that in nuisance, right? There are public nuisances, and government can bring forward public nuisance claims on behalf of citizens. But generally speaking, in private law remedies, it is the citizens that have a direct role in seeking redress from these personal harms. In public law remedies, they're different, right? So citizens aren't guaranteed, as we said, standing or the ability to bring a lawsuit for a violation of some of these federal environmental laws. So citizen suits aren't automatic. They're not automatic. And some statutes contain citizen suit provisions, but they're qualified. Qualified meaning other things must happen. You must show other things, or you must show certain things before you're allowed to bring it as a citizen, or other entities must attempt, like the government, attempt to bring a suit first or choose not to do it. So generally, in many of these federal environmental laws, you must allow the government the option to sue. And that means that there's a notice requirement at the least. So if you're trying to sue as a private citizen, you must show that you've provided government with the notice of the potential violation that you're claiming, and that government has either chosen not to act, or some period of time has passed since government's been put on notice and simply they have not acted. So if government chooses not to sue, then you must provide. So in the situation where government has either that timeline has passed or government has indicated they will not bring forward a lawsuit under this particular environmental law, then you must also still show capacity or standing. And standing is really about, there are three elements. It's, again, its own entire area of law to study, but standing requires you must show an injury, whether an individual or entity that is bringing the suit, private citizen, organization, group, non-governmental organization, must show injury. You must show causation, that the injury was caused by whatever the offending or violation of federal environmental law. And you must show redressability. And that means that that the judicial branch can do something to redress. Can it, is there something in the statute that allows them to stop and redress the harm that you're claiming in this case? Do they have the statutory authority? So we go back to that sort of judicial interpretation and judicial authority for remedies under the public statute. So just as a general view, we can say citizen suit provisions. Where do they exist? Under the Endangered Species Act, the ESA, yep, you have citizen suit provision. Under the Marine Mammal Protection Act, nope, there is no citizen suit provision, must be government only. And under the Clean Water Act and Clean Air Act, yes, but they are qualified. So there are citizen suit provisions, but generally speaking, you must put government on notice first. And then, government has the ability to act or choose not to act, that kind of thing. And then if you can prove standing, then you are capable of bringing a suit under these qualified conditions. So that's just some examples of where do these sort of public laws and for our pollution purposes. So the Clean Water Act, Clean Air Act, it's yes with qualifications if we're thinking about public controls of pollution. Here's an example, and I've copied and pasted this out of some of the written lecture notes for the students that are in the course. But as far as citizen suit provisions, the Clean Water Act example, here's generally speaking how you go about citizen suit in the Clean Water Act. First, you got to prove standing, that injury in fact. You must show that you've been injured by the action, the causation. We must show the injury is caused by the purported violation, and redressability must show that the court has the power to redress the injury. So that's first, there's got to be standing. Second, you must show, so as a preliminary matter, it's like, well, if other procedural issues are out of the way, do you actually have standing under this statute? And that's what you must prove. Second, then you must show government is unwilling to seek an enforcement action. So that in the Clean Water Act, there is a 60-day notice to the government required under the statute. You must give notice of the violation of the government, and then it has 60 days under the Clean Water Act to determine if it wants to prosecute. So that's one of the situations where government says yes or no within that 60 days, or it simply doesn't act within that 60 days, and you show that the 60 days has expired and therefore move forward because otherwise you have standing. And third, under the Clean Water Act, can only bring an action for future violations. You must show a continuing ongoing violation in order to actually, from a citizen standpoint, bring an action because government has to have, because the court has to have a capacity to provide a remedy, and it can only, under citizen supervisions, provide remedies for current and ongoing violations. So we talk about that as future violations, like I'm filing this today, but whatever's happening is happening, and it's going to happen tomorrow and the next day unless you take some action. And only the government under the Clean Water Act has the capacity to bring an action for past violations. So if the entity has cleaned up their act, pun intended, I guess, or unintended, then, if they no longer are committing violations of the Clean Water Act, then the citizen has no authority to bring forward a suit. Only government can bring forward that suit under the provisions of the Clean Water Act, where the court can act retroactively for past violations. Here's a couple of special questions or special cases, policy questions that we can talk about. So larger for public control, larger sort of scoped questions where we think sort of large scale. In terms of attainment areas, this is under the Clean Air Act, national ambient air quality standards. One of the things we can think about looking at putting on our policy hats is, what about areas where air is cleaner than it needs to be? The Clean Air Act identifies areas, and we talked about this, air sheds. And then in those air sheds, it allows states or state or states, depends if it's totally within the state or between two states, to determine the appropriate air qualities. We talk about what is the air quality, what does the air quality need to be? The federal government often identifies air quality for human health and well-being, a minimum target of air quality. There's some discussion with the states under the act about, does that air quality need to be cleaner than the minimum? What are the reasons, that sort of thing. But there's a sort of federal and state interaction to determine standards. Well, how clean does that air need to be? So often there are places in the country where the air quality, the current background air quality, rural areas, areas where there's not a lot of industrial activity, etc., is cleaner than what the air quality standards are. So what happens in those situations, where you have the air cleaner than it needs to be, and that might create an incentive for that area to say, hey, you know what? Hey, industry, come to New Mexico. We have really clean air that's cleaner than it needs to be. So here's the thing, you can come here instead of the current, you're in California, you can't emit you have to spend all of this money on this technology controls, in order to prevent the amount of pollution, because you need to maintain this particular air quality standard for that area. But forget about it, or Ohio or something, and come here. Come here because you don't need to spend all that extra money on all that technology control, because you can make our air dirtier than it is today, and it will still be clean relative to the air quality standard that's set, because our air is cleaner than it needs to be, just as a matter of background conditions. It's interesting because obviously that creates somewhat of a disincentive, right? That says, look, now you can start pushing economic activity to different parts of the country where it's sort of a race to the bottom, where you can start saying, look, we have cleaner than need be air standards, so come and help dirty our air. And it makes it more economically feasible for those companies to do that. And you have to ask yourself, is that the point? Is that the purpose of the Clean Air Act? Is that what it's intended to be? So maybe we think about, one of the things that we don't talk about a lot in terms of the environmental law is, why do the statutes say what they say? Why do they act the way they do? And should they be different? So what we're talking about here in these policy questions is just starting to think a little bit about, hey, should the Clean Air Act be different than what it says right now? Should it act a little bit differently? That's one example. Emission credits is another example. So the 1990 amendments to the Clean Air Act, cap and trade of sulfur, it's done a great job. So we had a cap and trade program started in 1990, and it significantly reduced the amount of sulfur in total in the air in the United States, and in particular air sheds. Sulfur is terrible because it creates acid rain and all these other things and that sort of thing. And we wanted to control it. And the way we thought of controlling it is using market forces. And the best way we could think of to use market forces is in a cap and trade system, is what you do is you say, look, the total amount of sulfur that we had before the system, it was 1 million pounds of sulfur. So now next year we have to be at 900,000 pounds of sulfur total. We don't care how you get there. So you can engage in all kinds of activities. So, again, you can move, sulfur. How do you reduce sulfur? What's the best way to reduce sulfur? Well, some places have the ability to scrub it because they already have technology. It's easier for them. So if you scrub the sulfur out, now you get sort of an emission credit, right? Because you were allowed to have so much sulfur from your facility, but you can go under that because of the technology you currently have. And therefore, then maybe you can sell your additional sulfur credits, the things, you could have polluted, you could have, had more sulfur emitted from your facility, but you didn't need to. So now that becomes valuable to other places that need to emit more sulfur under their new cap than they can by implementing new technology. And if they pay you less for those additional sulfur credits, than what it would cost them to implement new technology to scrub out the sulfur, then they're going to pay for your sulfur credits. And so that's sort of how it worked to create a sort of a market system in sulfur. Now, that was fascinating because it was a very efficient way in order to reduce overall sulfur emissions. What it didn't do is it didn't decrease sulfur emissions equally between 1990 and, let's say, 2022. It didn't reduce the amount of sulfur evenly across the country. As a matter of fact, what you saw in many areas, you saw sulfur increase relative to other areas in poorer regions, we call it disproportionality, and decrease faster in wealthier regions. Overall, over a long period of decades, sulfur reduced everywhere. It's good. It's good as a final result. But the process was unequal in how it played itself out. And again, generally speaking, if you overlay socioeconomic conditions to communities and you look at how sulfur reduced or how it changed, you would see sulfur spiking, actually increasing over that period of time. In certain areas with lower socioeconomic conditions, lower socioeconomic variables, basically poorer communities, their air got dirtier. Their air became, more hazardous to not only humans, but also the surrounding, because of the acid deposition, the sulfur deposition through mostly acid rain. It tends to stay in the area after it moves out of the smokestacks. You're burning coal, basically, that has high sulfur content in it, instead of scrubbing that out before it gets out of the stacks, and then it moves into the air, and then it deposits itself within that. Generally speaking, it depends on where you are in the country, generally speaking, within a relatively close proximity to the smokestack. How big the smokestack is, the prevailing winds, where you exist, all of those things matter. But generally speaking, you would see sulfur, the ambient air levels of sulfur in lower socioeconomic status communities increase relative to higher socioeconomic status communities. So we can look at that and say, overall, good success. The way in which we got there, some problems with disproportionality, because the results of the effects of that sulfur are borne by those that live in the area. So you have health effects, you have, well-being effects, all the types of things that are difficult. We can also think in terms of emission credits, something a little more recent is that sort of like, you think of like an auto manufacturer like Tesla in California. So there's federal emission credits that are given to automakers as a result of federal law, Clean Air Act, and some other federal laws. Because automakers generally have, internal combustion engines, historical automakers, GM, Ford, et cetera, certainly Toyota, but I'm just thinking US auto manufacturers. So, and as an incentive for them to move to zero emissions, to start removing carbon emissions, car companies were given incentives or credits, for having what proportion of their production line is zero emission. Tesla benefited hugely from this because Tesla started as a zero emissions company. It never built an internal combustion engine car. It started right away with battery cars. And as a result, a windfall, both at the federal and state level, because California also has its own incentives of credits, basically. And these credits become incredibly valuable because if you're, again, under this sort of cap and trade system, if you're GM or Ford or other manufacturing companies in the auto manufacturing companies in the United States, and you're still building in internal combustion engines, and you cannot move that quickly to others, or even if you're not in California, for example, if you're another company that needs these carbon emission credits, let's call it, because it's not for sulfur, this is for carbon, and you're a company that has a lot of carbon emissions. And again, there's Tesla. And if it costs you $1,000 to reduce for each ton of carbon to meet that reduction in your state, but Tesla can sell you an emission credit because it has a ton of them, because it doesn't, it gets, because it's an auto manufacturer and it has no carbon emissions in its production process. So, or very little. And certainly if we're talking about the output, the cars is zero because none of them produce carbon in and of themselves. They don't use gasoline is the main reason for that. It depends on where the electricity comes. There's a lot of other factors, but let's just say that as a result, they're only looking at the actual mechanism for moving the car is being electric. So therefore they're saying zero carbon and giving them lots of credits. If Tesla can sell to that company, instead of them paying $1,000 to remove a ton of carbon, Tesla could sell them that credit for $900 per ton. They're going to buy the Tesla credit. Tesla earns significant amounts of revenue. Still does, but in the early days, significant amounts of revenue to keep it going, in part, through these credits. when it was losing a lot of money, allowed it to expand. So they were really important in developing these types of credits in developing, nascent industries, let's say, like a fully electric automobile company, which, go back 10, 15, 20 years was sort of unheard of, right? The idea of it's really hard to penetrate the existing sort of paradigm or path dependency of internal combustion engine. It's just really hard to do it. So things like this are really important in helping to move policy forward. These types of sort of actual, like these credits can be used in different ways. Very beneficial for Tesla. Of course, on the other side, it's easy for Tesla to obtain these credits based on its business model. And then in part, it allows a company like Tesla to help support dirty industry, if we use carbon as an indicator of dirty, but carbon intensive industries that otherwise would have to have changed their behavior patterns without the credits to move under a particular cap, a particular regulatory limitation on carbon emissions. So we can think about these sort of the two sides of that coin. So we have attainment areas, emission credits, and then another example that's talked about, and this is in the book for those that are in the course, and for others just to understand these different sort of larger policy questions from pollution standpoint. There's in the United States, there's Eastern versus Western coal. This is historical. Coal is really not a significant sort of industry anymore. It's not a significant input in terms of generating electricity, and it's reducing in many ways still today, and likely to go further and further away as we move towards more renewable sources or non-carbon intensive sources. Historically, though, and this is still true, is Eastern coal out of Pennsylvania, Virginia, West Virginia, et cetera, in the eastern part of the country, it has a lot of sulfur as a natural condition. The type of coal it is has a lot of sulfur attached to it. It's sulfur heavy coal. Whereas Western coal, Nevada, New Mexico, Arizona, that coal has low levels, low concentrations of sulfur. So just by happenstance, really, just by geological sort of happenstance, it's very, if we're talking about sulfur as being the problem, then Western coal is much cleaner vis-a-vis acid rain than Eastern coal. And so if you think of the 1990 amendments to the Clean Air Act, I told you it was a cap and trade program on sulfur. Well, if you're sourcing your sulfur from Western coal after 1990, if sulfur becomes an issue, it's much easier to meet those without having to install scrubbers and high, and costly technology. It's much easier to reach those caps of sulfur, those reductions in total sulfur emissions, simply by purchasing Western coal. Makes Western coal competitive to Eastern coal. That creates its own problem. Because of this, Eastern has lots of sulfur and Western has low sulfur. So you can imagine what happens to the Eastern coal industry. So you're going to pass a federal law that's now all of a sudden, saying sulfur has to be reduced either through technological advancements, through passing of credits, or finding alternative sources. Move away from burning coal maybe, or coal that has a lot of sulfur in it if you don't want to put in the additional technological advancements, if you don't want to spend that money. So you can see the problem that creates, and you can think of that, and there's a whole history to this, and there's a whole political influence campaign, and so there's a discussion about how that plays out, and then how the Clean Air Act and even the amendments, the 1990 amendments, how they ended up reading in order to ensure that we weren't prejudicing Eastern coal against Western coal and exceptions. And the whole point of there is that politics really matter. So when we think about policy, often we think about policy in a vacuum, policy development. In other words, what's the best solution to this problem? And you can define that. But when you think about it in a vacuum, what we're saying is we're controlling for all kinds of other incentives. And some of the incentives from the idea of the straight line getting from the problem to the goal, solving the problem in a straight line, all those sort of parties and incentives, they create all kinds of deviations from that straight line. But they're really important because they speak to Congress, they speak to our political process, lobbying, and they have an important voice. So the point there is that we really need to understand the dynamics of what's happening. When we offer a policy proposal as a solution to a problem, we need to think about what happens to all of those players. What are the players? What are the unique circumstances? Is there a circumstance like Eastern coal having a lot of sulfur versus Western coal having very little sulfur? Because that then creates incentives, a whole set of incentives, and that can affect outcomes, goals and outcomes. It seems like it's easy to get to the goal, but that creates all kinds of incentives and sometimes perverse incentives, that sort of thing. And those are really important things to consider when we're thinking about how the law, and even if we're just trying to understand the Clean Air Act what it looks like, why it says what it says, and why does the statute operate the way that it does. How did all of those incentives play into the development of that statutory language? And then there's also federal jurisdiction. When we say federal jurisdiction, we're talking about when does the federal government have jurisdiction over issues? What counts? And the Clean Water Act has to be a really good example in terms of what's considered waters of the United States, what counts. Remember, this is talked about at the beginning of our overview in environmental law, but here in the United States, we operate under a system of federalism. We have a overarching federal government, and then we have sovereign states that are sovereigns to themselves. Obviously, they're sovereign states, so we have states, 50 states, and some territories, but those states are their own sovereigns, come up with their own laws, and they have the right to make and do and handle a lot of what goes on in their own territories. The 10th Amendment to the United States Constitution reserves all powers not enumerated specifically to the federal government, reserves those to the states, generally speaking, health, safety, and welfare. But in terms of waters of the United States, why this counts is because under the Clean Water Act, you have a federal law that's attempting to regulate a lot of bodies of water across the United States. And the question is, does the federal government have jurisdiction to regulate bodies of water that are within specific states? And here we get to some fascinating sort of policy dynamics when we think about a couple of cases. SWANC is one of the cases. It's an acronym for a local county. I can't remember the specific acronym, but it's one of these U.S. Supreme Court's decisions on the past couple of decades that's important under the Clean Water Act, because it, for one of the first times, once the Clean Water Act was passed, there was a lot of sort of like a lot of support for federal jurisdiction. And then SWANC came along, and SWANC said, there are the intrastate bodies of water. There are these bodies of water that are wholly within the state and have no connection to other bodies of water or beyond anything that goes beyond the state's boundaries. And for those bodies of water that we can identify, like ponds and things like that, that aren't connected to larger watershed ecosystems, that don't drain into a Mississippi River and then move from one state to the other, that kind of thing, and move through states. For that water, if that water is wholly within the state, then that water is not subject to the jurisdiction of the Clean Water Act. It is a state jurisdictional question, not a federal jurisdictional question. And that's important because if anybody understands watersheds or watershed ecosystems, they really are, the sum of the whole is greater than the parts. So you really can't say, well, this body of water, this pond, because the pond ends up supporting, and in SWANG in particular, it was about birds, migratory birds that were moving from pond to pond and different, between states. The point is, these bodies of water create, parts of they support an entire ecosystem that moves beyond the boundaries of states. And they certainly have hydrologic connections, even if they're not obvious, they do. It just depends on your definition of hydrologic connection. One of the ways to look at the SWANC decision is what it did is it said, look, we can't say that the Clean Water Act has ubiquitous jurisdiction over any body of water anywhere, no matter how small, no matter how, because then that just means the federal government's jurisdiction goes too far. There is nothing reserved to the state when it comes to bodies of water or water regulation. The Clean Water Act regulates everything. It is ubiquitous, it is everywhere. And if that's the case, then there is no water regulation outside of the Clean Water Act, meaning that the Clean Water Act sets the minimum standard for every state. States can go further, states can do more, but the Clean Water Act is subject to all water everywhere in the United States, subject to Clean Water Act jurisdiction. And SWANC said, no, that cannot be true. A more recent decision, Rapanos, different makeup of the court, and this shouldn't always be the case because of stare decisis, but different facts also. Rapanos, and I think 2007 approximately, said that, look, many of these water bodies, that even if they look like they're intrastate, wholly within the state, they are connected to watersheds. It took a much more ecosystem approach. And it said that because of that, if you can find this nexus, and this nexus doesn't have to be just hydrologic, if you can find a nexus and define nexus as more of an ecosystem-based definition, between these bodies of water, that they flow together as part of a watershed and then move into larger bodies of water that move into water systems, whether that's underground, whether that's above ground, right, that move into water body systems that then move between states, then that is sufficient for Clean Water Act jurisdiction. The point for us to know here is that just because there is a federal law called the Clean Water Act doesn't mean that it applies to every body of water in the United States. There are difficulties when we think about federal laws as a policy mechanism because of federalism and because we have this shared governance structure between federal government and states as their own sovereigns. And because of that shared relationship, no one law at the federal level can necessarily apply universally to everything that we'd want to maybe control, or at least it's difficult for that to be obvious at the start. And that's important to know from a policy standpoint. Okay, so to sum all of this as far as public pollution control, to sum up these thoughts, all of it, and to also sum up a bit of the entire section on pollution. Private remedies. Private remedies, we remember, direct access to judicial review. So you have a citizen, an individual that files a lawsuit, and that lawsuit is against a supposed common law, action, nuisance, negligence against the activity of another. It's specific to that activity, and the courts have a wide range of discretion in deciding liability, deciding, remedies, deciding all of the things that, relative to that specific facts. So you have direct access as a citizen, but you have limited application, meaning that it only applies to that situation. Whatever the court determines is the end result only applies to that specific factual situation. So that's important from a larger policy perspective. As a mechanism for controlling environmental harm, probably not the best, because it's very limited in its approach. From public remedies, much wider in scope, but more limited access to judicial review, right? Citizen supervision is limited, et cetera, right? And even when there is judicial review, that review is more limited in scope. It's limited judicial discretion, statutory interpretation, what the statute says, what it allows, not only in terms of, authority and the types of things, the types of harms that can occur, but also what are remedies and how can those remedies be applied. So much more expansive definition of environment, these public law remedies, right? But much more limited in terms of discretion. So from a policy standpoint, we can ask, look, neither approach is complete. They both have their, pros and cons depending on how you're interpreting. Again, if we're interpreting from a widespread, our desire is to create a widespread policy that is universal and applies to all things that are important vis-a-vis our definition of environment. And if we take a natural resource definition of environment, we certainly want it to apply to anything. So if we say the clean waters of the United States, we want it to apply to every water. So federalism is an issue, right? The idea of the statutory language is an issue. The idea of fashioning remedies is an issue, right? What does Congress allow? That sort of thing. So if we wanted the widest goal and definition, we can see that neither approach is complete. The question is, how do they comprehensively working together offer a policy solution? And how is that policy solution framed? Is it framed from an economist or an ecologist perspective? Those are the things I think we can take forward. That's the kind of framework we can think about as we try to understand the larger context. There's so many details to know about these laws. We can't get into all of the details, but as a general sort of schema, we can say, yep, we have environmental laws in the United States that apply to pollution. We have some private control mechanisms. We have some public control mechanisms. We understand their characteristics. We understand how they work, generally speaking. We understand the process in which they operate. And we understand some of their sort of like the powers that are inherent with them and some of their limitations. And that's really where we're at and where we should be at to understand this area and move forward. So that's all. We've concluded our discussion of pollution. We now move on to land use as we continue in our overview of environmental law. Thank you very much.